All right, welcome back. This capsule is dedicated to the case of Gosselin versus Quebec. This is the case for the Monday of the third week, and this is a case that you probably saw from the file. It's extremely long, and therefore you're only reading the head note. So of course, what I usually say on head notes, right, not being allowed to cite them, does not apply here. When you're only reading the head note, you don't have to cite to paragraph number, for instance, on your paper. So here, right, we focus on a number of issues that we saw earlier. The key one is the one that we saw last week about this concept of positive obligation. So of course, right, the court is going to go over kind of the general principles for section 15 again. I've mentioned them last class in kind of a bit of a recap at the beginning of the class. I won't do that again. The court goes over the broad principles under section 15, and then, right, the court applies it to the case, makes arguably new law here, specifically on the issue of positive obligations, right? So, what's the issue, right, we discussed last week? We said essentially positive obligations don't exist. So basically, right, there is this constitutional allocation of duties by virtue of the Canadian Constitution. It says the government passes laws, the court essentially strikes them down, right? Court considers whether the law has been validly passed, consider whether the law complies with the requirements of the Constitution, which since 1982 includes the Canadian Charter of Rights and Freedoms, which can invalidate a law that is not compliant. It's the role of the court, right? A check and balance. The court considers whether the law has been validly passed and whether it complies with the Constitution. However, it's not the role of the court to tell the government to either pass a law in the absence of a law, right, or tell the government specifically what it's supposed to do in doing that. So the government is going to have to first, right, this is a requirement that we discussed in our last session very extensively, has to be prescribed by law. So there has to be a law, right, by virtue of your judicial legal interest that I mentioned on Wednesday, but also by virtue of the wording of the provision. Section 15 says it has to be a limit essentially provided by law. And therefore, right, for you to go to court, you have to show that the alleged discrimination flows from a law, either in its impact, purpose, or in its application. So the court doesn't come in and tell the government, in the absence of a law, that it has to pass a law, namely because the person is disadvantaged, or the person is treated discriminatorily because of society, right? Or the person doesn't have equal access to various things that they're not, quote unquote, legally entitled to. Well, in that case, the court doesn't tell the government to pass a law. In this case, we have a lady who basically is asking for welfare, right? So, in that sense of positive obligations, the lady couldn't say, right, to the government, pass a welfare scheme, we need money when we don't have a job, and it's not fair in a wealthy country such as Canada for people to be on the streets and not have money to eat. In the absence of a legislative scheme, and I touched upon these issues quite extensively last week, as in terms of what it means to be in the absence of a legislative scheme. If there's no welfare scheme, the person can't go to court and ask the government to get a welfare scheme by alleging either that the person is treated discriminatorily, right, that they've been historically disadvantaged or are currently being discriminated against, or based on some other rights. In the Gosselin case, right, the right to life, liberty, and security of the person is invoked. Section 7, we talked about that already. Section 7 says you have a right to life, liberty, and security of the person, and a right, quote, not to be deprived therefrom except in accordance with the principles of fundamental justice. Of course, and the court came up with these principles of fundamental justice, right? And they're the reasons why you can limit that right. Well, in that case, if you don't get your welfare scheme, arguably that right might be infringed as well, right? You might say it infringes upon not just my dignity, and therefore you might say there's an infringement of Section 7, which protects your right to life, right? Liberty and security of the person. Security of the person generally means that there shouldn't be, right, undue threats to your life, right? That's how the prostitution prohibitions were invalidated, basically, right? Prostitution was illegal, and essentially, right, what the government showed is you couldn't have, right, the prostitute do it in their place of business because that would be a brothel, which is something that was prohibited by law, right? So you couldn't have a whorehouse, essentially, a place where prostitutes engaged in sexual acts, because there was a specific, right, legislative requirement that said you couldn't have that. And therefore, right, people who wanted to engage in prostitution had to do it in an unsafe situation, namely on the streets, in a hotel, or by going to the client's home, which is less safe than doing it in their own home, where they can just kick the person out if they want to, right? Well, as a result of that, the court said, even though no one died, right, there's no right to life, right, your right to security of the person, your right not to have your life threatened, and your right specifically to, right, not be in a position where, right, you either suffer or have an undue limitation to what you can do. There's also liberty in Section 7, right, life, liberty, and security of the person, right. In that case, right, there might be an infringement of Section 7. So in that case, right, arguably if you don't get your welfare scheme, well, you might ask the government to pass one based on both 15 and 7, equality and life. It's basically what the claimant is doing here. But as we said, there's no such thing as a positive obligation. In its simplest form, there is no obligation for the government, even if the situation is generally discriminatory or unfair, there is no obligation for the government to proactively pass a law to make it better, to provide a benefit to a certain group of people who deserves it, or to pass a welfare scheme to make sure that people don't starve, because the government has its legislative prerogative to decide both how it spends and allocates money, but also how it makes public policy decisions, so decisions regarding governance, right, by doing just that, by spending or not spending money. So the issue here, right, unlike the cases for basically all the weeks we've read so far, you have quite a number of dissenting judges, right? So we have a full formation of the Supreme Court, right? So you have 9 judges, and you have quite a number of dissenting judges who disagree on the very basic principle there. So last week's case was also about positive obligations. You had a unanimous court. So the whole Supreme Court agrees on the general principle that indeed there is no positive obligation to pass a law, generally, to remedy discrimination. However, right, it's not always clear whether you're asking the government to pass a law or whether you're asking the government to fix a law that is not correct but has been passed, right, that has a constitutional deficiency, and that's where it's going to turn here for the dissenting judges. So government passes a welfare scheme, right, essentially the welfare scheme that we all know about, right, and then creates an exclusion, right, basically for young people. So the government says, right, essentially what we hear in political discourse quite a bit, right, you know, experts might disagree on that. Generally, we don't want people to be on welfare, they can work, right, and there's this idea in the collective psyche that it's a big problem that we have a lot of people who won't move their butts and go to work, right? So that's what the government thinks, arguably preconceived notion, and says, we gotta get these people to work. So what are we gonna do? Well, we're gonna cut the money. And so we'll tell them you have to go to these programs where you learn how to get a job so that you get a job. And if you don't, right, we will take away your money. And quite a bit of your money, if my memory serves me well, it's 2/3 of the amount. So basically, what you get in Quebec, I think, is pretty minimal. I think today it's just under $700, which you're expected to survive on for a month. Government cuts 2/3 of it. Really hard to survive on $200 some a week, right? And Ms. Gosselin says, this is infringing upon my rights. How is that? Well, quite unsurprisingly, first it's discriminatory, and second, it infringes upon my right to life, based on what I've mentioned earlier. Because clearly there's a distinction on age. If you're a certain age and you don't go to the course, we cut your money. Age, again, is an enumerated ground. So subsection 15.1, which says you can't discriminate, has a list of enumerated grounds, right? So you have to discriminate not just on anything, right? On an enumerated or analogous ground, which is generally a ground that furthers substantive equality, that helps people who've been traditionally disadvantaged. Hence why I said a couple times earlier, you can't have a program that remedies the historical disadvantage of Caucasian people. That benefit provided discriminatorily would not be protected under Section 15, even though your law otherwise makes sense and meets the criteria. Ms. Gosselin says there's a distinction drawn on age. Pretty obvious, right? There is indeed a distinction, namely that if you're a certain age, they cut your money. If you're not, they don't, right? First, again, this very sophisticated test that we've mentioned many times, right, of discrimination under subsection 15.1, right? There has to be a distinction. So the person in court or the group of people in court, right, in a similar situation have to be treated differently than someone else, right, by implication, based on one of the grounds, right? It's also part of either step 1 or step 2, but it's a third thing that's very important, and it has to be discriminatory. So within the sense of subsection 15.1, which furthers substantive equality, you'll recall from the law case, the third class, the court gave a bunch of indicia. It's not determinative, right? And the court admits in the law case that it's difficult to define discrimination, and it's difficult to define human dignity. And therefore, the court gives some indicia, right? Court says if you're being prevented from being a full member of Canadian society, if we're perpetuating historical disadvantage, if we're drawing a distinction based on a stereotype, so a characteristic that's attributed to a certain group, generally that is not correct, right? Generally not based on fact, but based on historical assumptions. These are all things that can make a distinction discriminatory, and therefore, right, call upon the application of subsection 15.1. Here is a distinction based on age. Age is an enumerated ground, so in the list of things, not limitative, in subsection 15.1, right, you have a list of things that you can discriminate upon. As I said, not limitative means you can prove other ones, right? Age is in there, is in the list, and therefore you do have to show that it's based on age, but you don't have to show that age is one of the things that you can discriminate upon. But of course, the distinction has to be discriminatory, right? No one argues there's a distinction because the law says on its face, so not in its effect, in this language, right? The language of the law says we cut the benefit that much for that group of people. So specifically, a distinction in the law on its face based on age, but it has to be discriminatory. And the majority of the court finds, reasons we'll see, that it is not discriminatory. So why is that, right? Well, because essentially, right, all the things I've just mentioned on human dignity don't apply, right? People age 30 are not a historically disadvantaged group. They're not a group of people who've been prevented from participating in Canadian society, and they're not a group who are stereotyped, at least according to the majority. And so even though there's a distinction, it is not discriminatory. Now, the way we call upon the application of these positive obligations, you ask, is through the Section 7 analysis. Obviously, this is a Section 15 course. It's not as important for our purposes. But basically, there's a subsidiary argument there, as I said, about the right to life, liberty, and security of the person. So Ms. Gosselin doesn't just say this is discriminatory. She also says this is in violation of my right to life. In other words, the government has to give me welfare and not cut it. Because even if the government cuts it for good reason, so even if Ms. Gosselin, right, through the entire fault of her own, Ms. Gosselin, right, is available to go to the course in the morning to learn how to get a job. She's available, she's healthy, she's woken up in the morning, but she doesn't go. It's her fault, there's a clear requirement, she can meet it, doesn't meet it, chooses not to meet it. Well, the law says Ms. Gosselin doesn't get her welfare money. 2/3 of her welfare money she doesn't get. Well, Ms. Gosselin says, yeah, that's provided by law. I didn't respect the requirement. But you can't do that because I'll starve. That's Section 7. So Ms. Gosselin says there's a positive obligation there. The government has to not cut my welfare, even if I don't go to the course. Because if the government does that, the government violates my right to life, liberty, and security of the person. Namely, the government puts my life at risk, my security of the person at risk, by putting me at risk of starving and dying. Essentially, that's our argument. And there's also a subsidiary argument, pretty interesting, under the Quebec Charter of Rights of Human Rights and Freedoms. It's been criticized for demeaning the Quebec Charter of Human Rights and Freedoms. Obviously, there's historical reasons why Quebec is the only province that has its own charter, even though we have a federal one. But significantly, it's not the same kind of a charter. So the federal constitution, which includes the Federal Charter of Rights and Freedoms, was passed in 1982, as I said, right? And it has supra-legislative status, right? So it can invalidate other laws by virtue of the fact that it's a constitution. And one of the reasons for that is it was passed differently, right? So you don't pass it with a simple majority, you don't cancel it with a simple majority, because otherwise it would kind of defeat the purpose, right? Some government that doesn't like constitutional rights could just cancel them tomorrow morning by being a majority in parliament, right? So you don't enact it with a simple majority, you don't cancel it or revoke it with a simple majority, right? And additionally, by virtue of that, it has a higher status that can invalidate other laws. That is not true for the Quebec Charter of Rights and Freedoms, because there's no such thing as a provincial charter in the sense of the federal one that can invalidate other laws. And so you can pass a law, like any other law, that calls itself a charter, and where you say this can invalidate other laws. You can do that by virtue of your legislative power, but it's still a law. So it might invalidate other laws, but only because you said it could. So it's still a law that's been passed with a simple majority that can be revoked with a simple majority. So to call it a charter is kind of misleading, at least in the sense that we've construed charters so forth based on our federal conception. And the Quebec Charter of Rights and Freedoms has this very peculiar recognition of a lot of rights that sound very good, right? So the Quebec Charter isn't just going to say the government can't kill you, the government can't jail you without a reason, the government can't torture you, right? Can't treat you discriminatorily. It's also going to say a lot of things like the government has to give you a house, right? Has to give you proper housing, access to public education, proper housing, and so forth. So ostensibly, Ms. Gosselin might have a right to get that welfare pursuant to her right to get, say, a house, right, or adequate housing, which is provided for in the Quebec Charter of Rights and Freedoms. Similarly, there's a right to an adequate standard of living in the Quebec Charter. Well, Ms. Gosselin might have a right to her welfare based on that. And in fact, she might have more than that. She might have a right to get a middle-class living because that's what you might term adequate. But, as the court finds, these rights don't have any value, essentially, because the Quebec Charter also says, yeah, but these rights you can't really go to court with. And so, even though there's an ostensible infringement of, these rights, so there's an infringement of a right to an adequate standard of living, to adequate housing, these are rights where the Charter says they're not justiciable. So in other words, you can't go to court and invalidate a law on that basis. And that's the court's conclusion on that. And there is an invocation of the notwithstanding clause, which is something we'll consider in our course on Bill 21, which we'll discuss quite a bit in a further session of this course. The notwithstanding clause is a legislative device or compromise. It can be used by governments to basically not have to respect the Charter. So, seems a bit odd, right? You have all these constitutional rights, which the government technically can't infringe upon unless it gives a good reason within the meaning of the reason-giving provision, which is Section 1 of the Charter of Rights and Freedoms. But you can use the notwithstanding clause, which says this law doesn't have to respect the Charter because we said it doesn't, right? But you're told the notwithstanding clause in that case expired, so it no longer applies. That's by virtue of a historical compromise, because the province of Quebec never signed the Canadian Constitution for historical reason when it was patriated in 1982, and therefore there's this mechanism there, essentially because Quebec never signed the Constitution, so it kind of is unfair to have a Constitution that applies to everyone, including Quebec, which didn't sign the Constitution, has a quarter of the Canadian population, and can't get away from these constitutional rights. Obviously, there were secession issues at the time as well. So you have, 4 judges dissenting. Quite a split court there, right? And quite significantly, the 4 judges who don't agree really do not agree. So they don't just say, well, we're not sure whether it infringes these provisions or not, right? So you have basically the majority saying there is no infringement of 15, of 7 of the Quebec Charter. And then you have the dissenting judges saying there is an infringement at least of 2 of those. And we'll see why that is in a bit more detail. So first, the majority decision there. One of the things that's mentioned, page 431, is the burden, which I will use this lovely opportunity to reiterate because I mentioned it quite a while ago already. So what is the burden of proof? Well, of course, the burden is on the claimant. If you want to go to court and say you've been discriminated against, we will expect you to show that. And so you have the burden to adduce relevant evidence to show that there was indeed discrimination. In other words, there's no presumption when you come in a court that there was infringement. And it's not for the government to show that there wasn't. Instead, it's for you to show that. As we said, there's still Section 1 of the Charter, which is an extrinsic limit. So this is all nice and good, You can have a discriminatory distinction, but the analysis, as we said, but won't see in great detail, doesn't end there, Because there's Section 1 that says all of the rights under the Constitution, not all of them, but the vast majority of them, can be infringed upon in a limit that is kind of reasonable, basically. And we have this thing called the Oakes test, which specifies what a reasonable limit is. And therefore, at that point, the government can say, yes, there was discrimination, but it's allowable, or a violation of any other rights, Otherwise, the government really couldn't pass any laws. At that point, the burden is on the government. This is not something we look at in great detail again, but at that point, the burden shifts. And so you have, as the claimant, the obligation to show the infringement. Once you've shown the infringement, you've gone all the way. You showed all the tests under Section 15. then the government has to show that the law is justifiable under Section 1. In other words, if the government wants to invoke Section 1 to save the law by saying it's indeed a violation of your rights, but it is reasonable, then it is for the government to show it. So it's not for you to show that it is not reasonable, it's for the government to show that. Page 432, you have a taxonomy of age distinctions, right? Why is that there, right? Seems a bit odd, right? You have race, right, gender, all the things that generally we expect discrimination upon, and then you have age, right? Even though you don't have gender orientation or other things that we might think people are more susceptible to discrimination based upon. Court says, basically, it is common to have distinctions on age. Well, we know that, right? Often, what you can do, what you get, will depend on your age, right? It's true under pension regimes, which is an example that we saw, where the court says it's not discriminatory to tell younger people you don't get your survivor's pension if your husband dies, because it's not a distinction, even though it's a distinction, that is discriminatory, because younger people are not a historically marginalized group, and on top of that, there is good reason to believe that young people, right, do have different abilities. And so this is not a stereotype. We don't assume young people can get a job. Generally, it is true that it is not a stereotype, it's an actual characteristic of young people that they get a job more easily. Basically, the court says, generally this protection for age is used for that. It's used to protect against the assumption, read there, not factual, and therefore a stereotype. That's what a stereotype is, right? An assumption that's not correct, right? The assumption that older people are not capable or have certain limitations. And the court gives the historical context of that provision. Essentially, right, there was a recession at some point where lots of young people were unemployed. They were not eligible for federal unemployment benefits. Basically, the way federal unemployment benefits work, you pay into a system based on payroll taxes. And so you have a certain salary, you pay into the system, kind of as a tax. And then if you're unemployed, you get some money, but it's limited, right? And so what happens when you run out of that insurance, employment insurance, or you never paid into the system in the first place, you go on welfare. And so that's what the program's there for. Welfare was there because we didn't want all these young people, right, to do that. They end up starving, but then, right, the government realized, at least that was its assumption, right, you'll see the dissenting judges don't think that's correct. The government assumed that all these people were staying on welfare, and the government thought, well, that's not really good for our economy that we have all these young people who could get a job who choose not to get a job because they'd rather get welfare, basically, right? And so, right, the government's purpose was specifically that, right? In cutting that, right, the government wanted to get these people off welfare. So the government said, you go to the course or we take your money. Well, right, that's a means that is quite related to the purpose. It does make sense that if you take away the money, people are going to go to the course. And if your assumption is that your course is going to get them back to work, well then it does serve your purpose, right? The means you're adopting, which is this exclusion we've discussed, right, does serve your purpose, namely to get these people back to work. And the majority finds that this is precisely the kind of remedial stuff that we like. In other words, you'll recall 15.2 says, right, remedial legislation is allowed, right? So you can pass a law that says we're improving the state or condition of these people, right? Even though it might be otherwise discriminatory. And the court says, in kind of a similar way under 15.1 here, right, this is good, this furthers substantive equality, right? So 15, right, for distinction to be discriminatory, it has to not be consonant with the purpose of section 15, which is to further substantive equality by helping historically disadvantaged groups. here the government says, first, young people aren't a disadvantaged group. Second, right, this is good for them. The government is doing the right thing by forcing them back to work, which in the end is going to make them happy. Court even says it's an affirmation of their potential and therefore not a denial of their dignity. And the court uses this very sophisticated reasoning method that we discussed earlier, which is logic and common sense. In other words, the court makes assumptions that are not otherwise borne out by facts. And so here, right, the court doesn't ask for study statistical data. So we said, right, generally you have to show things when you go to court, but the court can take, right, some shortcuts. Generally because Section 15 claimant or regular people who don't have sophisticated legal representation, and so the court can use judicial notice or common sense to draw these conclusions. Here, namely that young people have an easier time getting a job and that the program is likely to shift them back to work by doing what it says it does. And significantly, for reasons of judicial precedent that we won't get into, right, the court had to owe deference to the trial judge's conclusion. So first, this case went ostensibly before the Quebec Superior Court, right, which is the general court of constitutional jurisdiction. So the Constitution says if you don't know where to go, you go to Superior Court. There's one in every province. It's the same constitutional court. You go to Superior Court. Then you go meet a judge, right? Then the judge renders a decision. If you're not happy, you go to the Court of Appeal. Again, constitutional court, but there's one in every province, Quebec Court of Appeal. Then you try to go to the Supreme Court. As we said, you have to ask for permission, right? You don't have a right to go to the Supreme Court. You have to ask for leave. Leave has to be granted. So what happened there? Well, first they went to Quebec Superior Court. And the trial judge at the Superior Court made a significant conclusion, and that is that it is, right, not correct that, for instance, there were not enough places in the program, right? So, in other words, and this is significant, if people wanted to attend the course to get the job, but they couldn't, then it might be discriminatory. So, if they go to the course, it's good for them, there's room for them, and it furthers their independence and their flourishing, that is not a discriminatory distinction, even though it's a distinction based on age. But if they can't go to the course, right, if for some other reason the government's trying to do something sneaky there, it's just trying to starve young people by creating a course that's not available. It's not allowable. That might be a distinction that's discriminatory, because then it's not based on fact, right? Then it's not a distinction that helps, right, further their flourishing, and it's based on their actual ability to get a job. Then it's just unfair. It's based on that crappy program where even if they want to, they don't get to the course. Well, the trial judge concluded that, right, that was, quote, unsubstantiated. So in other words, not true. And for reasons we won't get into, generally concerning judicial efficiency, you don't get to start over your trial 3 times over, even if you get to the Supreme Court. Certain conclusions of fact, courts have to owe what we call deference to. So in other words, have to respect that. Generally because the trial judge has the entire factual record, has witnesses before them, sees if they're credible or not. On appeal, at the Supreme Court, it's not the case. And so the court says we're bound by this. So it might be a discriminatory distinction based on age if it didn't, right, meet their actual abilities. If that distinction, that inability, right, to that potential of getting your welfare cut, right, was not related to the purpose or was not related to the characteristics of young people, that is, that they can get a job because they might be able to get a job, might want to go to a course but can't, then it might be discriminatory. But the majority says we can't get into that because we're bound. We have to respect the decision of the trial judge. And the court says, it looks at both the looks at the similar timeline for the purpose of the law and the impacts, and that's significant, right? So here, of course, in the short term, you might hurt young people, right? You might cut their welfare if they don't go to the course, and then subsequently, right, they might have a month where they don't get any money, and then, right, they wake up the next month and they think they really have to go to the course because they won't get their money, for instance, right? Pretty simple factual scenario there. Well then, in the short term, you're not achieving the purpose of getting them to the course. The only thing you're doing is taking away their money. But the court says we have to look at the purpose of the law, and that is in the long term to move these people back to work. And therefore, these short-term effects don't have to correspond with what the government's achieving. Because obviously cutting money in itself doesn't help them get a job, right? It incentivizes them the next month to wake up and go to the course, and that eventually, right, logically, without proving it, right, is likely to get them better access to a job. Then section 7, obviously the majority says not a positive obligation, and so section 7 cannot be used to say you have to have a positive obligation to provide people with a welfare scheme. Then we'll consider the various dissenting opinions. Obviously, we should stress multiple times that these are not the law, right? Obviously, the majority wins. The majority decides what is the law. This is all stuff that is not binding Supreme Court precedent, but it's very interesting because as opposed to all the unanimous courts we've had so far, here we have a very divided court, 5-4, where there's obviously legitimate disagreements between very smart people as to whether or not the issue that's raised there of cutting welfare infringes upon Section 15. And you have the judges write separate dissenting opinions, so even the people who disagree can't agree amongst themselves on why they disagree. And that's going to be significant and interesting because it raises underlying broader issues about Section 15. And obviously the court's going to, the dissenting judges, are going to look at the same framework, and they're going to consider the same underlying policy issues, which we can better understand by considering how certain judges came to a different conclusion, even though that is obviously not the law. First, Justice Bestarache from Quebec, right, you might think that's relevant based on the scheme, says basically, right, makes some detailed conclusion about Section 7, not relevant for a purpose, then finds that it infringes upon Section 15. Then he reiterates what I said, right, has to be considered from the perspective of the claimant, and we have to see whether it prevents them from participating in Canadian society and the various other indicia, which I won't repeat again. And he concludes that, and I quote, the distinction was based on the stereotypical view. So as we said, a stereotype is an assumption that is incorrect, not borne out by facts, by statistical data. Stereotypical view that young welfare recipients suffer no special economic disadvantages. In other words, and this is kind of tricky there, not that relevant if you don't understand it, but he says, we're cutting their money because we assume that they can get a job. Well, the other way to phrase this is to say, we assume that they have no special disadvantage. We assume that cutting their money ain't gonna hurt for these reasons. And he said that that's not correct. You might say, I might say that he seems to reverse the burden here. Because the government doesn't have to show, you'll recall, and that's just my opinion, you might disagree during our discussion session, but the government doesn't have to show that it achieves the purpose. So, let's backtrack a bit. We discussed that twice already, but it's important, right? So the government says, we want people, young people to get jobs, and we'll do that by cutting their welfare. So, what's the standard on this? The Supreme Court, of course, doesn't assume that what the government says is true. The Supreme Court isn't going to say, well, you said it, so it must be true. You're the government. It's not sufficient. So the court's going to look at whether it's logical. That's how I enunciated the standard. Whether it's rationally related. That's the legal version, right? So whether, right, cutting welfare seems to be logically a way to potentially get these people back to work. That's the standard. The court doesn't look at whether that's factually correct. In other words, right, the government doesn't have to come in and say, here's the proof our law works. Here's how we got 20,000 people back to work. That would be too much of a burden, and you'll recall one of the reasons I mentioned for that is that oftentimes the government just passed a law, there's no way to prove that it works, right? But here Justice Bastarache seems to ask that of the government. Seems to say, well, you didn't prove that young people can get jobs. That's just my opinion again. But he might be reversing the burden there, and that might be why it's an incorrect conclusion. And then undertakes a contextual analysis, which is required, and then he says, right, basically this is all based on assumptions that are not borne out by the facts, i.e. a stereotype, and a stereotype is one of the indicia we mentioned that can make a distinction discriminatory because it offends human dignity. So even though young people are not a historically disadvantaged group, it's still an enumerated ground, so age is one of the things you can discriminate upon. And, right, if you stereotype young people, even though they're not typically stereotyped, then potentially that might be a discriminatory distinction. And so to kind of push that further, if that's a question that might come up, right? So I said you can't discriminate against Caucasian people. That's correct, right? You might still have a stereotype of Caucasian people in some very, very arcane situation where technically Section 15 might apply. So you might have a law that says, right, oh, well, all Caucasian people are rich and therefore they won't get any money. Then that might be a distinction based on race, right? That is an enumerated ground. And therefore, if it's discriminatory, you might, right, discriminate against Caucasian people. But then it doesn't change the fact that generally Section 15 is to help historically disadvantaged group or prevent stereotypes or the other four indicia that we mentioned already in the session. And he also raises the other indicia, right? Not participating in Canadian society, right? Offends their human dignity, their ability to participate, and also, right, shows little respect for the value of these recipients. These are all indicia of discrimination that we've discussed quite a number of times already. And then he basically says, right, this reversing of the burden I've discussed, that the government is asking them to trust their intention as opposed to a demonstration that the purpose is likely to be achieved by the law. And then he gets back to these conclusions and says, it's discriminatory for the reasons I mentioned, because it is not correct that if you go to the course, you get your money. For other reasons that I mentioned earlier, you might be trying your hardest to go to the course and not get the money. Then that's potentially discriminatory. Well, you might ask, when you read it when you read it a single time, you might think, well, how come the majority has just completely ignored the fact that it does seem, right, that even if the thing seems to work in theory, the course is not available, and so even if people try, they can't go. That's unfair, right? And the answer I've given earlier by emphasizing 2 sentences out of a paragraph out of the 20 pages, and that is, it couldn't be revisited. Because the trial judge saw the facts, saw the data, right, and said it's not correct to think that people can't get access to the court, and therefore the majority said it was bound. Justice Bastarache, don't get confused by this, but kind of gets around that by saying, well, it's not that I don't agree with the trial judge's conclusion, I just find there's no data. And so There's no deference there if there's no data. Again, not particularly relevant for our purposes. And then he says basically it's discriminatory because it's based on age, not on need, not on actual characteristics that are legitimate to draw a distinction upon. Then the Section 1 analysis. So again, Section 1 can save a law. If it's reasonable, there's generally a bunch of principles, right? Gross disproportionality, overbreadth, right? They have very odd names. Basically, you look at the same thing that we looked at under Section 15 between the purpose of the law and the way it's being achieved. And so there has to be some proportionality there. There has to be a consonance between the two. In other words, if you put everyone in jail to avoid 2 crimes, it might work, but it's not proportional. It's not a way that minimally limits the rights of people, and therefore is a proportional limitation that helps achieve an important goal. And he conducts a Section 1 analysis and said, right, even with deference, right, even by assuming that the government can make its own public policy decisions, it just doesn't cut it, right? There's just no evidence of what the government is saying, right? And the government has just not considered, right, the rights of these people around the age of 30 and their actual capacities and whether there's actual data for what the government is asserting. This is something very interesting, page 439. When the potential deleterious effects, the bad effects of the law, namely that you don't get to eat, the legislation are so apparent, it is not asking too much of the government to craft its legislation more carefully. Very interesting argument, right? Basically the exact opposite of the court's conclusions, of the majority's conclusions, and he seemed to defend it with the same vehemence there. Then there's a bit of stuff on remedies, so it's not something we'll look at in great detail. Section 24, you can see it's running out of ink there, but Section 24 is the remedial provision. You don't have to focus on it too much, but basically, of course, there's something in the charter that has to say, right, what happens if you infringe upon the charter. So you'll recall I said generally the law is invalid. Well, there has to be a provision that says that. And Section 24 says you can invalidate a law if it doesn't comply with charter rights, and you can also get damages based on a standard that's very high and essentially never applied. Any other judges, the other dissenting judges, come to somewhat different conclusions. We won't get into them in great detail, but essentially, right, they raise the same issues, right? They raise the same issues as to the government basically drawing a discriminatory distinction because there just wasn't access to the program, right? It wasn't possible for people, even if they tried, to get access to the court for all sorts of administrative issues. And then there's also an interesting issue on positive obligations, which we'll close on. Justices Arbour and Le Redubé, who's a notorious critic of inadequate government policy, to put it mildly, right? And they conclude that there is a positive obligation. That's very interesting, somewhat outside the scope of this course, but I really hammered home the point on positive obligations earlier, right, and said, right, the court, the majority finds there's no obligation, even under Section 7, your right to life, liberty, and security of the person, to get a welfare scheme, to get the welfare, if you don't meet the conditions because you don't want to starve. Well, there's 2 judges, and that's quite a bit, right, who find that there is a positive obligation, and we won't get into that, but you have the justification there, which I alluded to somewhat summarily earlier, but you should probably read these 2 dissents with some interest because it really helps, right, highlight what is and is not a positive obligation. And instead of claiming, right, arguably, like Justice Bestache, right, that there is a positive obligation, but not calling it that. These two judges specifically say we call it a positive obligation, and we think that Section 7 does impose an obligation of the sort. And I think Justice Dorotbe even goes further, or Justice Arbour, sorry, and imposes upon the government an obligation to produce data, right, to prove its assertions. And so you see, right, that these principles under Section 15, obviously thus far we focused on what they are because that's far more important than the debate as to what they should be or how they should evolve, right? But you see that there's still disagreement on them. And that's true even though most of the cases that we read are generally unanimous. And so the court agrees on, right, substantive equality, purposive analysis, this test that we've discussed. You have a unanimous Supreme Court. These things are not debated. But on more kind of specific issues of how you affect that substantive equality, namely by positive obligations under 15 or 7, then there's disagreement even within the Supreme Court, and even on a relatively basic issue as to the fact that generally in law there are no positive obligations. And so we'll close on that. As I said, you can read the two dissents yourself, but you'll see that the reasoning really turns on that. Turns on the fact that the younger individuals, even though they might not have respected the courts, and so in other words, there is a legislative basis to cut their welfare because they didn't respect the rules. There's still, right, you still can't take away their minimal level of subsistence, and I think Justice Dorotbe, it is, says that government's own assessment of what a minimal level of subsistence is, and therefore imposes this positive obligation.